Welcome everyone, and please be sure to leave your audio on mute. And if during the presentation you would like to ask a question, if you would type it into chat and send that to me, that would be very helpful. Welcome everyone. We'll be starting the workshop momentarily.
All right. Okay, so good evening. My name is Father Jacek Orzechowski from Catholic Charities of the Archdiocese of Washington. I'd like to welcome all of you to this special Catholic Charities workshop on dealing with the threats of eviction during the pandemic and the steps that could be taken to protect oneself from becoming evicted. It's organized jointly by the Parish Partners Program and Parish Community Organizing and Advocacy of the Archdiocese of Washington. I would like to ask all the participants to turn off your audio. And please know that this workshop is being recorded. The Zoom program we are using does not allow us to see your email, so if now or later you join and would like to receive a PDF copy of the presentations and some other materials, please email me. And my contact information will be provided at the end of this workshop. If you have questions during the presentations, I would like to ask you to direct them through chat box to my colleague, Laura Yeomans. I would like to introduce to you our diverse group of presenters. First, it will be Kayla Williams. She is a staff attorney with Community Legal Services of Prince George's County, and she will discuss the current eviction moratorium and the eviction process. Next, Leo Green, who is a retired district judge in Prince George's County and who's currently working for Catholic Charities Legal Services, will speak about how tenants facing evictions can try to resolve their disputes with the landlord. The third presenter will be Carmen Castro-Conroy. She's a managing counselor in Montgomery County for a Housing Initiative Partnership. And she will speak about the emergency assistance resources available for members of the local community that are struggling to pay rent. And next, we will have Veronica Mosqueda joining us soon. She's a senior bilingual tenant organizer and program oversight lead with Latino Economic Development Center. Veronica will focus on the efforts of her organization to assist the renters in the district who are facing evictions. Lastly, I will highlight a few community organizing and advocacy efforts in trying to deal with the specter of expected avalanche of evictions. And I hope that towards the end, the last 25 minutes of this an hour and 15-minute long workshop will spend for Q&A. And now, without further ado, I would like to invite Kayla. And let me do the screen sharing. Okay. One second. All right. Okay. From the start. Can
Okay.
you see it? Yeah, okay.
Yes. Good evening, everyone. Again, my name is Kayla Williams, staff attorney with Community Legal Services. So how I'll proceed today is I will discuss the court's brief reopening plan. I will then get into the current eviction moratoriums, and then we will discuss when the landlord does file a complaint with the court, what those different types of cases entail, what they should look like. Next slide, please. Okay, so we are currently in phase 3 of the court's district court reopening plan. So that's from July 20th until August 30th. The court is hearing mostly all of the landlord-tenant actions. They're hearing rent escrow actions, tenant holding over actions, breach of lease actions, wrongful detainer actions. We'll discuss what these cases entail a little bit later, but just understand that these are proceeding. The court is not currently hearing failure to pay rent cases. Those are scheduled to begin in the next phase as early as August 30th. So if any failure to pay rent cases are filed before March 27th, if they're filed currently, those cases will be set on or after August 31st. However, the court's most recent moratorium has recently lifted. That expired on July 25th. So if there were any eviction orders that were entered prior to the court closing in March, those can be executed by a sheriff. As always, I'll give you my contact information, so if you have additional questions, you can reach out to our office. Next slide, please. Okay, so first we will talk about the current eviction moratoriums, and I'm speaking specifically to Prince George's County in this first slide. So the Prince George's County Council has initiated CB 16-2020. That was passed on June 9th. And what it states is the landlord cannot increase a tenant's rent if that tenant can show they've experienced a substantial loss of income related to COVID-19. And so that rent increase, if it takes effect during the state of emergency and within 90 days after, that rent increase cannot take effect if the tenant can show substantial loss of income. So that means that if you lost your job, if your hours were reduced, if you've lost childcare and you can no longer work, or if you get sick, a landlord should not be increasing your rent if you can show that substantial loss of income. Additionally, this bill also says that a landlord cannot impose any late fees or penalties to any tenant, regardless of whether or not you have suffered substantial loss of income. And this is effective throughout the state of emergency and within 90 days after. And lastly, this part specifically pertains to failure to pay rent cases. This bill states that a landlord is prohibited from filing a non-payment of rent case that was not initiated before COVID-19. And this extends through August 31st. So we're hoping that we get some type of extension, but as of right now, the landlord should not be filing non-payment of rent cases, and those aren't being heard or scheduled until after August 31st. Okay, next slide, please. Okay, so we get a lot of calls. So this particular slide pertains to some of the protections that our governor has put in place. The first states that there can be no utility service provider shut-offs. So your electric, your gas, your telephone, your internet, water bill, cable, etc. should not be cut off. Governor Hogan has initiated an executive order that says that this was in place throughout the state of emergency. So if for some reason your services are being turned off, you want to call the utility service providers, but you also might want to contact the Attorney General's office. Additionally, Governor Hogan has stated that during the state of emergency, the court is prohibited from entering an eviction order in a non-payment of rent case or in a breach of lease case if a tenant can show that they've suffered a substantial loss of income. This is why it's so important that tenants are given the opportunity to have a court hearing, because oftentimes there are defenses that you may be able to raise. So keep in mind, if you've experienced loss of employment, reduction of hours, lack of childcare, etc., you may have a defense according to Governor Hogan's bill, which prohibits the court from entering orders for eviction due to substantial loss of income. And this is throughout the state of emergency. Next slide, please. So although the CARES Act expired on July 25th, keep in mind that if your property was considered one of the covered properties under the CARES Act, your landlord is still required to give you 30 days written notice before filing an eviction case. So here's a link if you do want to check out to see if your property was covered. Next slide, please. Okay, so now we're going to talk about the prohibition of non-judicial evictions. So this is the statute. It's found in Real Property, Article 8-216. In Maryland, it is never legal to evict a tenant without a court order. What that means is you are always required to file a formal complaint with the court, and you have to, the tenant will be summoned to appear. They'll be allowed to tell their side. The landlord will be allowed to tell their side. Additionally, this statute indicates that just like a landlord can't lock you out or evict you without a court order, likewise, a landlord cannot, what they call, conduct willful diminution of services, meaning they can't turn off your lights or electricity. We'll elaborate on that on the next slide, please. So here is I created a little graphic so that you can see what the process should look like. So lawfully in Maryland, if a landlord does wish to remove a tenant from the property, they should go to the courthouse and they should file a complaint seeking possession of a property. There's several complaints that they can file, but this is the first step. Once the landlord files that complaint, a court hearing is then set in, and assuming that the landlord wins, the court will then grant a judgment for possession in favor of that landlord. However, that's not enough. The landlord must then obtain a warrant of restitution. Once the landlord obtains a warrant of restitution, assuming the tenant has no other defenses, the landlord then has to take that warrant of restitution to the sheriff's office. So a landlord can't actually evict a tenant on their own with a warrant of restitution. They have to call the sheriff's office and have the sheriff initiate that warrant. Next slide, please. So some examples of an illegal eviction or non-judicial eviction are if a landlord attempts to cut off your electricity, attempts to turn off your air conditioning, if they turn off your water, your heat, if they stop paying utility bills and it's so bad that they have to force you to move, or if they change your locks. These are all considered illegal. And again, your landlord must wait until the sheriff's office acts on the warrant. Your landlord can't just take that warrant or judgment and decide if they want to then change your locks or remove your belongings. They always have to go to the sheriff's office. Next slide, please. So what do you do if you are illegally evicted? Our office typically tells tenants to either contact the Attorney General's office and file a formal complaint, or you can file a civil suit for damages. So if you've had to incur hotel costs because you've been locked out, you can't obtain your possessions, that may be something you can be awarded in a small claims action, or if your belongings have been discarded, or if they've been damaged as a result of the eviction, you may be able to file a civil suit as well. So in summary of this section, just understand that a landlord must always go through the court. They can't just send you a notice to vacate and say you need to be out by this date, and if you're not, I'm going to change the locks. That's considered illegal. They must obtain a warrant, a court judgment, and that must be executed by a sheriff. Next slide, please. Okay, so assuming the landlord does everything they're supposed to do, these are the different types of hearings that your landlord may file. So if you do see something like this, at least you'll get an idea of what these different types of cases entail. So we'll be talking about failure to pay rent, tenant holding over, breach of lease, and wrongful detainer cases. Next slide, please. So the most frequent case that our office sees are failure to pay rent cases. These are cases in which a landlord is seeking possession of a rented property based on the tenant's alleged non-payment of rent. And if you're you can check out Maryland Real Property 8-401. So this complaint can be filed by a landlord's agent, or an attorney. The complaints may include base rent and late fees plus additional rent. We'll talk about that in the next slide. And keep in mind that these cases that I'm talking about today, they're all dealing with judgments for possession, so they're possession cases, meaning that the landlord is simply seeking to evict a tenant based on whatever complaint they're filing. whereas a small claims action is a money judgment case, we're not necessarily talking about those. But there are two different types of landlord tenants. Possession and the money judgment case. No, please.
No. Solamente jail.
So this is a, I've kind of created a case or complaint. As you can see, I've highlighted the sections that should be filled out. Oftentimes, if these sections aren't filled out correctly, you may be able to raise a defense. For example, if the landlord didn't provide notice to the tenant or didn't put that tenant's name on the complaint, if they didn't indicate where the tenant lives, if the landlord hasn't stated whether or not they're licensed, they haven't stated for what months they're asking for rent, if their late fees are over 5%, etc. These are all defenses, potential defenses that you are able to raise. So when you get that complaint, you want to make sure that you keep it and you bring it to court if you do receive it. That way your attorney may be able to help you raise these defenses. Next slide, please. So what is rent? We can kind of skip this slide. This is a little legal. You all will have it. Keep in mind, in Georges County, and several other municipalities in Maryland, a landlord is required to have a rental license to rent the property. Keep that in mind. So if you are summoned to appear in court, you want to make sure that your landlord does have a rental license. Next slide, please. So also in Maryland, if your property was built before 1978, your landlord is required to certify whether or not that property was affected by lead paint. And if it is, they have to get it certified to make sure that if it was built before 1978, it must be certified that it wasn't affected by lead paint. That's also a requirement on the failure to pay rent complaint. Next slide, please. These are some of the potential defenses. We've kind of already highlighted those on the red on the complaint. So we can go to the next slide. Okay, so the important thing about a failure to pay rent case is even if the landlord obtains a judgment against you, you always have the right to pay that amount of the judgment to stay at the property. This is called your right to redeem. So if for whatever reason, the landlord says that you owe $1,000, and if you can come up with that money anytime before the sheriff comes, you get to stay there unless you have 3 or more judgments for possession within the last 12 months. And the landlord has to specifically ask for your right to redeem to be taken away. So keep that in mind. Next slide, please. Tenant holding over. Essentially, what your landlord would need to prove is 1, that you had a valid lease, 2, or that you had a valid lease or you were on a month-to-month tenancy, 2, that your landlord gave you proper notice to vacate. Typically, that's going to be 30 days notice, but it may be more if that's in your lease. Sometimes it's up to 60 days. 3, that you still reside in the property, and 4, that your landlord wishes to regain possession of the property based on your lease having expired. That's essentially what they would have to prove, and that's what this case entails. Next slide, please. A wrongful detainer case is essentially a homeowner is saying to the court, there's someone who lives in their property who does not have a legal right to be there. If that homeowner can show that they own the property, say by producing a deed, and they can also show that the person who they are seeking to remove has no legal right to be there. For example, that person is not a tenant, they have not been awarded possession of the property by court order, that they're merely a house guest, then the homeowner may be successful in this type of case. So this is called a squatter's rights or a guest, if you want to remove a guest from your property. Next slide, please. And finally, we have a breach of lease case. This is essentially where your landlord is alleging that you've breached a term of your lease, that breach is substantial and that it warrants an eviction. They also have to give you proper notice. Typically, it's going to be 30 days as required by the statute. Sometimes it may be 14. Next slide, please. Okay, as always, here's our contact information. I've also listed some other helpful resources. I know I kind of flew through these slides, but just for the sake of time, if you do have additional questions, feel free to reach out to us. Thank you.
Thank you, Kayla. And this is Kayla's contact information included here on this page. And now we would like to segue to Leo Green.
Thank you, Father. I want to thank Kayla. She did an outstanding job of giving a really complex landlord tenant in a very short period of time, and she covered it outstanding, unbelievably well. And just as a background, um, I spent 18 years of my life as a judge. Last July, I joined Catholic Charities Legal Network, and I can't tell you how pleased I am to be with this group. Every day I get to see people in distress, and I get to work with them. I feel very blessed. Sometimes I'm successful, sometimes I'm not. As Kayla will tell you, as a lawyer, we don't count our wins and losses. We just care how we take care of things. And Kayla is with a really, really good group in Prince George's County. We're really blessed to have them in Prince George's County, and they're extremely helpful in the landlord-tenant area. Catholic Charities Legal Network is more of a one-on-one group. We're your arm of the church. We're with Catholic Charities. We're just a small group. We're not as big as Community Legal Services. We have 3 lawyers that are set up in the Susan Mona Center, which for anybody who knows, that is a center that's in Temple Hills, and it was specifically set up to be in Temple Hills to serve the poor and the needy in the southern part of the county. So we work with folks. We take people's calls all the time. We work with people as they have problems. Many times the landlord-tenant problem is not the one that we see the most of. One of the things we hand out, as Kayla does, is we hand out a district court pamphlet that is frequently asked questions. And Kayla did a great job of explaining all of that already. But these are online, and you can get them at the Maryland Judicial website. We give these to folks immediately when they have a landlord-tenant question because it outlines what they can do and what they can't do. I want to just take a few moments, not a lot, to just talk a little bit about the process that Kayla outlined. You know, one of the things that you look at is the majority of the cases are failure to pay rent. If I had in a given day the time as a judge that would say possession, 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 I would go nuts. I mean, I at the end of the day, I didn't want to hear the word possession because that's all a judge says after failure of rent, landlord possession. And then they set, as Kayla pointed out, they set a redeeming amount. And that's the amount of money that you can pay to have the possession lifted. Now, the key with this is that a landlord cannot act or cannot ask for a writ of an eviction or a warrant of eviction within 7 days. So the person gets the landlord files the action, let's say on August the 1st. Generally, the court is going to set those 7 to 10 days later. And that is when you have this quick hearing. And the quick hearing is held, and it's very quick. There's at least, the judges moving fast. Judges generally have anywhere between 400 and 600 cases a day to handle landlord-tenant cases. And they are moving their dockets. I mean, it is built, the district court is built on speed, economy, and it's built to move cases fast. So it's a fast moving pace situation, and folks get lost in there too. So we want to talk with them long before the case. One of the biggest things I think you can do for what I call poor law lawyers, such as Kayla and I, is to get the person to the lawyer as fast as possible. I can't tell you the number of cases where I'm driving to the courthouse in Upper Marlboro to handle a case for a person, and I get a call from somebody at a parish staff that says a parishioner needs help in landlord-tenant court that day. The key and one of the biggest things you can do is get them to us early because early determination and early work is great. Even if we have post possession. I've been a lawyer in this county since 1985 and working for Catholic Charities, obviously, for a year. I have never seen anybody evicted within 7 days after the court date. I just simply have not seen it. I once said that in the company of the then sheriff and another deputy sheriff at lunch, and they both quickly told me they had, but it was only for a very prominent politician who was a landlord. So this stuff it moves fast, but it doesn't move fast in that regard. And the sheriffs get backed up. Also, one of the things we'll see is that the administrative judge, the sheriff, they have a lot of discretion in holding stuff off for a lot of reasons. So it's not a complete panic if somebody gets an eviction notice or it gets a failure to pay rent, but it's going to move quick, and we want to see them as fast as possible. One of the things we're investigating are 3 things right now that we're seeing cases on. Is one, and Caleb picked up on it, is that these breach of lease cases are now becoming more prevalent, meaning they're never going to replace the failure to pay rent cases. They're just never going to get to that stage. But landlords are getting smart, and they're getting it very ingenious in how they come around and do it. So if they see somebody who's not on the lease that's living in the property, or as we've seen in several cases now where one family has moved in with another family, and there's, every case is different, but it's maybe a 2-bedroom apartment, and they've got 12 to 15 people living there with 2 families living in sleeping bags and children under the dining room table. They go ahead and file a breach of lease case because, the lease says they should have X number of people, and that's that. And it's an intimidation thing too. One of the things we are seeing more and more is not benevolent landlords, not the compassionate landlord that I like to see. And I've dealt with a few of them, be honest with you. Most landlords are fair people, but they are business people. But I have seen in the last 2 or 3 months a fair number of what I call compassionate landlords. And as people of faith, that's great to see. But it's the big business ones that we have the problems with, where they're dealing from corporate and different things of that nature. So the breach of lease is coming in more. We want to explore that. Also, we want to know if they're in federal housing and different things of that nature. I'm not a fan, I'll say it publicly, I'm not a fan of this president at all. I'm simply not. But his recent executive action his executive order may provide some fodder for us lawyers. We're still investigating, we're still looking at that from federal housing situations. So that's a positive. And I haven't heard many positives come out of 1600 Pennsylvania Avenue, but that's life, and I've got to live with that. Bless me, Father, for I've sinned. I probably shouldn't have spoke too harshly about another individual, but that's just my political.
No, not at all. Not at all.
You'll give me absolution?
Oh, absolutely.
Okay. All right. Thank you, Father.
Justifiable.
All right. But the bottom line is, we're here to help people. And you saw my contact information. I'm more than willing to help. We have basically another lawyer. Basically, we call each other gray lawyers because we both got gray hair and we're both over 60. Not like Kayla, who's, still got that great young look and that energy that we all love. You can see it in that smile. But the bottom line is that, if you want to help folks, get them to us early, and we will investigate and we'll look at things. It's hard each case is individual, each one's an individual. And again, I can speak for Catholic Charities Legal Network that we do not discriminate in any way, shape, form, or manner. We will never ask you if you're a Catholic. We'll never ask you what your sexual orientation is. We'll never ask you anything about your religion, your creed, your sex, your different things of that nature. Sometimes they come in play because we do represent some folks that have some discrimination. So that is where we may have to ask you, but we're open to anybody and everybody, not just Catholics. So with that, Father, I'm going to just kind of move on and give you I'll wait till the Q&A. But Kayla did an outstanding job there. It's always showing up us old judges. So take care. Thanks.
Thank you. And we're going to continue with Carmen Castro. Let me play from the start. Carmen?
Yes, thank you, Father Jacek. So I do have a presentation that covers a little bit of what we heard from Kayla and Lee already. So I will try to cover information that we haven't heard yet. I'm a housing counselor, work from the Montgomery County Office of Housing Initiative Partnership. We are an independent nonprofit, HUD approved, and we have an office in Hyattsville and 2 offices in Montgomery County. Next slide, please. Okay, so I just wanted to start with just what kind of programs have been put in place as a result of the pandemic. And we heard already the federal moratoriums on eviction that expired July 24th. We are constantly trying to keep up with what's happening at the federal level with the extension of the moratorium and how that will affect states and properties within the state. The next program that was announced earlier during the pandemic was the economic impact payments through the CARES Act. Some people refer to it as the stimulus check that was only available to certain income. It was based on income, and it was handled by the IRS, and the amount of the checks that households receive vary from $1,200 to $2,400. I just want to let everyone know that if a family that's eligible for this stimulus check has not received their check, they should go to the Get My Payment page of the IRS to see if they would be eligible and sign up. The deadline is October 15th. The other program that was created to support families affected by COVID-19 was the Federal Pandemic Unemployment Compensation. That was an additional $600 a week in unemployment benefits. Unfortunately, that has expired at the end of July. So now we are hearing from families who haven't got those additional payments and are starting to struggle with payments. Next slide. So that was at federal level. In the state of Maryland, we had an order from our governor early on March 16, where he declared state of emergency, and basically ordered the courts to hold on to any of the eviction cases due to inability to pay rent as a result of COVID-19. And that order still remains in place. We're still under state of emergency. And that also included another order with the provision of the termination of utility services. That order has been extended, and we're currently under the latest version that's supposed to expire September 1st. And I just want to make sure that we all understand all the utilities that are included under this order are electricity, gas, water, sewage, phone, cable TV, and internet. In addition, no late fees could be charged during this time. The other area that was important, I think Kayla already covered, is in regards to the reopening of the Maryland courts. We're currently under phase 3. Next slide. So basically, beginning July 25th, that's the phase we're in. Cases will be heard in court will be filed in court, and hearings will be scheduled after July 31st. So there are a couple of programs. The state of Maryland has also designated funding One of them is through what's called the DHCA Assisted Housing Relief Program. This is specific to properties that are financed by DHCD, and the assistance will cover up to 4 months of rent. If you believe that you live in one of these properties, you can contact the management office directly, and they will give you additional information. And the other program is the Maryland Eviction Prevention Partnership that's gonna distribute CDBG funds to all 24 counties and jurisdictions within Maryland. Next. So a couple of things that have been available in Prince George County. One of them that haven't heard yet today was the prohibition of rent increases. That was dated June 29th. So we have some additional protections that allow for the covered residential rents and including storage rents during the state of emergency. And the program that was announced early this year after the pandemic was the ERA, or the Temporary Emergency Rental Assistance Program, where applicants could get up to $1,800 or no more than $1,800 or 3 months of emergency rental assistance. The word is that the additional funding may be given to this program to reopen application, the application process is currently closed. Next. So in Montgomery County, the County Council also passed a Renters Relief Act on April 24th, which would limit the rent increases to no more than 2.6% during the state of emergency. We know that the city of Tacoma Park has their own rent control policies, but the cities of Rockville and Gatesburg adopted similar measures like the county did. So there are currently 2 programs in Montgomery County to help families affected by loss of income, the families that are struggling to pay their rent. This one I wanted to include in my presentation. It was announced today. It's the COVID-19 Rental Assistance Program that will be administered by HOC. The application process starts August 18th through August 31st. So I encourage families that are impacted by loss of income to go directly to the HOC website. If they're Montgomery County residents, they may be considered if they meet the criteria. So all of that information will be, it's available already on this website for HOC. This program will basically help households with up to $600 a month for 3 months, and those payments will go directly to landlords. And the other program in Montgomery County that was recently announced was the rental assistance for evictions. That's an additional $20 million in money to expand the rental assistance and to help families avoid eviction. The program will be administered by DHHS. The funding will be available in late August. And families that want to have access to this program, they need to call 311. There is currently a waiting list, but families that have court notices or a higher risk of eviction may be given priority. So everyone is encouraged to call 311. This information I think we already covered earlier. I think Kayla did a lot of coverage for this. I do want to repeat the importance of sharing this information with families that are being notified with court notices for failure to pay rent. To basically, they all have the right to go to court and present their case. And if they can demonstrate that they were impacted by COVID-19 through loss of income, they will be protected by the moratorium from the state. Now, as a housing counseling agency, we provide comprehensive, individual, confidential sessions to all households that reach out to us by phone. We're working remotely nowadays, free of charge. And our services cover rental counseling, foreclosure prevention, post-purchase, pre-purchase. And what we do the most is to inform all of the families that call us about the programs that are available, about the eviction process, their rights as tenants, and we do as much as we can in like providing other referrals to other programs that would may supplement income, like access to food programs, county programs, state programs. We work with municipalities and advocate on behalf of clients. So that's the message I want to share today, that we are available. You can see our contact information right there for both of our offices in Montgomery County and Prince George County. And I'll stick around if anybody has any questions. Thank you, Father Jacek.
Thank you, Carmen. And now we continue with Veronica Mosequeda. And hold on a second. Okay, here we go. Veronica, welcome.
Hi, everyone. Can you hear me okay? Can you hear
Yes.
me? Okay, great. I've been having some issues all day, so thank you. Thanks for having me on. Yeah, my name is Veronica Mosqueda, and I am a tenant organizer at the Latino Economic Development Center here in Washington, D.C. Should I mention a little bit of the work we do?
Yes, briefly. Mm-hmm.
We work with tenants to exercise their TOPA rights, which is the Tenant Opportunity to Purchase Act right, which allows tenants to have a say of what happens in a multi-unit building when it goes for sale. We support tenants with technical support in creating tenant associations. We support in evictions, court accompaniment, and we support in support tenants launch rent strikes when they are fighting to hold abusive landlords accountable. A lot of our work is also policy related, so we are working right now on the Cancel Rent campaign, as a lot of folks have been impacted by COVID-19, and we recognize that you know, the burden of seeking support should fall on the landlords and not tenants who are already going through a lot. So I'm just going to work a little bit through what the rights are in the eviction process, but also just rights in general, not just during the pandemic, but in general. In the district, if a landlord wants to evict someone, they have to go through the court process. That is step one, whether it's in a single family home or in a multi-unit building. And because right now we are, you know, in this crisis, that process will be delayed because the courts are closed due to COVID. So for a lot of folks, that means that they'll have, you know, more time to save money if they are able to go back to work, or they are recovering some of their work hours as some of the restrictions are loosening up. We know that this isn't going to affect everyone positively because some people are still, you know, struggling and they're already really behind on rent. But also something to know that once courts do reopen and a landlord does start the eviction process for non-payment of rent, if a tenant is caught up by the time that eviction process has started, then someone, you know, a tenant cannot be evicted. Next slide. So your rights in the eviction process. The first thing that should happen when a landlord tries to evict someone is that they will receive a court notice. If that doesn't happen, then the process, it hasn't been started. So the first thing to always do is seek legal assistance. Oftentimes, this process is free or comes at really low cost. And you see there are a lot of pro bono attorneys and also a lot of attorneys that work with folks regardless of documentation status. It just, you know, depends on the firm. Because we are tenant organizers and we are not attorneys, there's only so much we can do and support with. So we always partner up with attorneys. We have a lot of attorneys that I'm still on the other slide. We have have a lot, we partner up with a lot of attorneys and can always recommend or at least give people the resources they need to get in contact with them. And an attorney can walk tenants through different possible defenses, right? Like if tenants are living in a multi-unit building and they are living in bad conditions, that's a defense, right? That can be used. And if there is documentations and pictures and all that, that also like supports that case, right? Or if a landlord started a case, but they didn't give proper notice, or they started a case they shouldn't have, that's also a legal defense. So that's why it's just so important to seek legal representation, because they will be able to assess that situation. Something we always encourage tenants about is just to be careful about talking to the landlord's attorney in the process, that they are always looking out for the best interest of the landlord. That is their job. They are not here to make things better for tenants. So we always recommend that they do not speak to the landlord's attorney without having their own legal representation. And last but not least, if a tenant receives a notice to vacate, that doesn't mean that they have to leave. It is, like I said, just the first step in the eviction process. Tenants still have to go to court, and because courts are closed right now, that eviction process cannot happen. So please always talk to a tenant organizer or an attorney about your situation, because there may be so many rights you don't know about that could really support you in this process. Next slide. So those were just very general, just even pre-pandemic, post-pandemic, that's just the tenant protections in the law. But the new emergency protections during COVID-19, they have shifted quite a few times as, you know, the emergency has been extended, but this is the most recent or the most up-to-date. So landlords cannot begin the eviction process at least until October 9th, which is when the state of emergency is scheduled to end. As we've seen, every time that the date is scheduled to end, it keeps getting pushed. So right now, this is just like the date we have right now. It could even be pushed to later on. And in most cases, this means that landlords cannot start a new eviction process and file a new case until 60 days after the state of emergency has been lifted. So that puts us in early December, right? Like December 9th. This unfortunately doesn't cover cases that started before the pandemic. So unfortunately, I think we are still going to see a wave of evictions starting October 9th, if that is when the state of emergency will end. Landlords can charge rent during the state of emergency, but they can't charge any late fees. Next slide. And other emergency protections that are tied to that date, that dynamic state of emergency, are that no rental increases are allowed right now. So this backdates to, March 15th. So if a landlord has raise someone's rent, that's illegal, and we encourage them to get in touch with us, and we will connect them with the Office of the Attorney General that is taking these increases very, very seriously and holding bad actors accountable. Utilities cannot be shut off during this crisis, and this includes water, gas, electricity, internet, cable, and phone. And same, if this is something that's happened, please get in touch with us, and we will work to get that remedied immediately, because we know that this is still something that has happened. And if a landlord has received more time to pay their mortgage, that means that tenants could also receive more time to pay their rent as well. Something that has been passed through the legislation is that also landlords can work out, landlords and tenants can work out like a payment plan that lasts about a year for those who couldn't pay, during this pandemic. So, and last but not least, the landlord has never has the right to ask you about your health. And this is, even like if we weren't living through this situation. Yeah, that's it. Next slide. Like I mentioned, we do some policy work, and right now we're working on the cancel rent campaign, and that is going to be a long fight. And that is a fight that has started since, since March. And we know that this is going to go into the next fiscal year, seeing that the budget season in DC just wrapped up. And it was a pretty contentious fight to even get the protections that we were able to get. So in the meantime, people are struggling, right? People are struggling, they can't pay rent. And we know that there are assistance programs that were created to support people in this situation, and programs that existed before. We recognize that a lot of these assistance programs don't address the root of housing inequity. But like we said, as we're working to dismantle systems that just don't work, we also have to work to meet the needs of people right now. We know that these assistance programs, unfortunately, we are one of the organizations that has also received funds from the federal, from the government for the tenant-based rental assistance program. And we have seen that, the funds are limited. There are obstacles and barriers to applying. And also sometimes this weakens even the power of tenants, because it just weakens the power of tenant organizing at times, so that's why we are working to cancel rent for everyone. And we know that if rent is canceled for everyone, everyone benefits, and folks wouldn't even have to apply for programs. And we are working really hard to also try to continue. We know that landlords, are businesses, and a lot of businesses have also, lost profits, aren't making profits. And we think that the burden of trying to find these funds are on landlords. But in the meantime, let me tell you a little bit about the programs that do exist in DC. Next slide. So there are 3 programs, one called ERAP, the Emergency Rental Assistance Program, so we'll start with that one. And then there's the CHAP and TBRA. So the Emergency Rental Assistance Program is, and I will say, this is not a program that we at LEDC support tenants with. So our knowledge of the process, the internal process, is very limited. But there are several providers throughout DC that are still open and accepting these applications. And to qualify, folks have to be at least 30 days behind on rent. They don't need to have a case in landlord-tenant court, nor do they have to have received an order of eviction. And I believe you don't even have to have proof of citizenship to qualify for this program. There are some limits to the Emergency Rental Assistance Program, that folks can only receive assistance once a year, and the time and the limit of and there's also a limit of how much each household can receive, which is the equivalent of 5 months of rent, or $4,250. It can be extended to up to $6,000 for households in which someone has a disability. And to qualify, the total income of the household has to be less than 125% of the federal poverty level. On this slide, I have also the links to the websites to be able to see who are the ERAP providers for more information, and these will be available after the presentation. Can we go to the next slide, please? So the second program is the program that came as a result of COVID-19, which is the DC Tenant-Based Rental Assistance Program. This is a program that at LEDC we are supporting with. We are one of 2 organizations in DC that got these funds. And right now, the eligibility for, right now we are taking applications. There are still funds left. Folks have to be living in a building that has more than 1 and less than 50 units. And they had to be affected by COVID-19. So if they were behind on rent in February or March, unfortunately, they wouldn't be eligible. And there is an income limit of 60% MFI, which off the top of my head, I don't know what that income limit is, but we have a number here, which is 202-524-0546, where if anyone wants to call or text, they can learn everything they can about this program. Our tenant organizing team is not in charge of this tenant-based rental assistance program, but the folks on the line, on the email or the phone will be able to answer all your questions and walk folks through that process. So in the email is myhome@ledcmetro.org. And again, these slides will be available. And also, oh, you know what? I have a note here. The 60% on a 5 for 1 person is $51,000. And then for a family of 5, it's $78,000, $660. So if that helps to actually get some numbers and not just percentages. So yeah, I think this is also a 6-month rental assistance program. And from what I understand, it will not cover the entirety of someone's rent, but it will cover the majority. So just heads up. Next slide. Okay. And then the last one, which is the COVID-19 Housing Assistance Program, that also came about from, the pandemic. And this program assists people who have suffered economically because of COVID-19 or the state of emergency. And this program can also assist tenants who live in larger apartment complexes, as well as those with higher incomes. So what we saw a lot when TBRA was launched was that a lot of folks weren't qualifying because they lived in buildings that had 100 units or more, or even like 58 units, and they were just immediately disqualified. So this is meant to really encompass the other sets of folks that just didn't qualify the first time around. And it's for folks who have a little bit of a higher income. To qualify, tenants must be behind on their rent and have to have resided in their unit since February 29th, 2020 or longer. And unfortunately, this program only provides 3 months of rental assistance instead of the 6, like TBRA. We do not we are not in charge of this program, the CHAP, but there are other organizations that I think it's on the next slide that do work with CHAP. Yep, there it is. It's like I couldn't remember. So yeah, some of the contacts to apply for rental assistance are on this slide. I do want to ask, does it make sense for me to, we could go back real quick for me to read all of those, or?
You know what, we're going to have that material available to anyone who wishes.
Okay.
So if we can, 1 second. We'll have some time for Q&A. I just wanted to briefly, before we do that. Okay, I'm sorry. Also, okay, highlight that when we're talking about advocating for renters' rights, there are a number of parishes in Washington, D.C. that are involved in Washington Interfaith Network. Always we encourage folks to take an active part and to push for systemic change. Equally, Action Montgomery, there is right now an effort to engage large landlords and to negotiate some solutions that could provide a relief. So anyone who is watching it and lives either in DC or Montgomery County is strongly encouraged to get involved and to be part of the solution. And just well, it's not part of the presentation on the on the issue of avoiding evictions, but we're talking about the funding available to the community and the need for to make yet another push to get people participate in the 2020 census, because a big part of the funding is also for housing and for health. So at this point, okay, and this is if you would like to receive a PDF copy of these presentations, and we also have some additional resources, please email me and I'll be more than happy to send you a copy of that material, and also a recording of this workshop. At this point, I would like to open conversation for questions to any of the presenters.
Yes, and we do have two questions that have been submitted. The first question for presenters: how do I go about to check if my apartment complex is covered under the CARES Act? That was submitted by one of our participants. So how do I go about checking if an apartment complex is covered under the CARES Act?
Sure, I can try to answer that question. The state of Maryland made an announcement that based on the eligibility of the apartment complex, there would be like a specific program to help tenants, help them with rent. That was an announcement made by Governor Hogan on June 26th through a press release. The number to contact, because there was a link that provided the names of all the properties within the state, but you can contact the Office of Public Information at 443-679-7653.
And if the property is in DC?
I don't know if, yeah, I actually don't have an answer to that, but I am happy to like look that up pretty quickly or check in with my team and follow up, honestly. I can put my email on the yeah, I guess I just don't really I don't understand the question.
All right. Question number 2, how do I go about checking if my apartment is a DHCD financed property? And what are the requirements for the 4-month rebate voucher? Thank you.
Right, so the DHCD, it's a program that's specific to Maryland, to the whole state of Maryland. The DHCD is the Department of Housing and Community Development. So you can go into that page and there will be a section that describes these programs that are available because of the pandemic.
Thank you. Any further questions? Okay, so if there are no questions, I would like to bring this workshop to a closure and thank to all of the presenters for this very informative presentations. And once again, we'll be making the presentations available. If you would like to receive it, just email me, and we'll be sharing it with within our Catholic Charities network with parishes, so that they can post it on their social media, and with other organizations that we collaborate with. So once again, thank you so much, and may God bless us all in the efforts to help people in need. Peace and all good.
Thank you, everyone. See you later.
Thank you.